Not satisfied with a decision made by the Traffic and Parking Commission, you may appeal the decision by filing for a writ of certiorari with the Davidson County Chancery or Circuit Court. Your appeal must be filed within 60 days of the date of the entry of the Commission's decision. We advise that you seek your own independent legal counsel to ensure that your appeal is filed in a timely manner and that all procedural requirements have been met. I ask for approval of the agenda of today's meeting, please.
So moved.
We have a first. Is there a second?
Second.
We have a first and a second. All in favor?
Aye.
Aye. All right. In regard to the minutes of the February 12, 2018 meeting, legal counsel, could you please advise?
We had some fairly extensive revisions to the minutes on the 51st Avenue issue, and because we circulated those so belatedly and the commission hasn't really had time to review them yet, I believe you preferred to defer the approval of the minutes. Is that correct?
That would be correct. Okay. So if someone would make a motion to defer the approval of the February 12th minutes, please.
Move to approve.
Move to defer. We need a motion to defer, please.
Move to defer.
Okay, we have a first.
Second.
A second. All in favor of deferring the approval of the minutes, please say aye.
Aye.
Aye. All right, the minutes have been deferred. All right. Approval of the consent agenda. Before we read the consent agenda, I'd like to get a motion to remove item C, please. There's been some.
I move to remove item C.
All right, we have a first. Is there a second?
Second.
Second. All right, all in favor of removing item C, please say aye.
Aye.
Aye. Are there any other items that anyone believes needs to be removed from the consent agenda before it's read? Yes, Ms. Kern.
I'd like to move to remove item
G.
G.
Okay. There's a first. Is there a second?
Second.
We have a first and a second. All in favor?
Aye.
Okay. All right. Being no other items, then I will read the consent agenda 0318. Item A, proposal 2018M004AB001, a request for the abandonment of an excess strip of right-of-way on the north alley of Hadley Avenue, excuse me, see plan of Berryville, Book 421, page 117 RODC-TN, between 1st Street and 6th Street, and being approximately 20 feet in width, or as determined by an accurate survey. This request excludes any right-of-way owned by TDOT for State Route 45, Old Hickory Boulevard, or currently in use by the public or public utilities. Easements are to be retained, requested by Metro Public Works applicant. Proposal 2018M005AB001, a request for the abandonment of a portion of alley number 1897 from dead end to behind 303 Tankersley Avenue and 302 Timmon Street. See sketch for details. Utility easement is to be retained, requested by Pam Kimbrough, applicant. Item D, authorize valet zone 5 spaces on west side at 221 5th Avenue North from the hours of 4 p.m. to midnight, requested by Parking Management Company. Item E, authorize loading zone hour change from 8 a.m. to 4 p.m. to 24 hours on south side of 101 Church Street at 1st Avenue North, requested by Ron Lim. Item F, authorize valet zone by combining 2 valet zones into 1 valet zone at 1910 Belcourt Avenue, hours of 10 a.m. to midnight, requested by Parking Management Company. Item H, authorize an all-way stop at 8th Street and Jones Street, requested by Councilmember Hager. Item I, authorize truck restrictions over 8 tons with 6 no trucks over 8-ton signs on Allison Place, Neal Terrace, and Carvel Avenue between Wedgwood Avenue and Southgate Avenue, requested by Councilmember Sledge. Item J, authorize no parking signs on Autumn Crossing Way on the east side at 200 degrees north of Scarlet Ridge Drive to 715 north of Scarlet Ridge Drive, requested by Metro Public Works. Item K, authorize no parking signs throughout the Indian Creek subdivision at the following locations, requested by Metro Public Works on behalf of Councilmember Bedney and the HOA for Indian Creek subdivision. A, Broken Bow Drive from Carter Wood Drive to Old Hickory Boulevard. B, TP Trace from Broken Bow Drive to Tucklegee Lane. C, Tucklegee Lane from Calderwood Drive to Dead End. D, Nantahala Court from Tuckaleechee Lane to Dead End. E, Calderwood Drive from Santa Leah Way to Dead End. F, Santa Leah Way from Stecoa Street to Calderwood Drive. G, Geoa Court from Santa Leah Way to Dead End. H, Stecoa Street, Oakfield Grove from Calderwood Drive to Tapaco Lane. Stecoa Court from Stecoa Street to Dead End. Chinook Drive from Stecoa Street to Dead End. Ocoa Lane from Oakfield Grove to Dead End. Mandane Drive from Tapaco Lane to Oakfield Grove. Otoe Court from Oakfield Grove to Dead End. Please, next time, give me pronunciation keys. Okay. After that tongue twister, the consent agenda has been read. A motion to approve the consent agenda as read.
I'll make a motion to approve, but Chairman, I would like to clarify for those looking at the screen, it looks like it says A through D, and that should be H through K. That's what's on our agenda, and that's what was
Okay.
printed, so just in case there's any
All right.
confusion on that.
Thank you. Appreciate your clarification.
Made a motion.
We have a first and a second. All in favor of approving the consent agenda, please say aye.
Aye.
Any opposed? It passes unanimously. Thank you. All right, we have two items that had been removed. First one was authorize additional parking spaces for the horse-drawn carriages requested by Sugar Creek Carriage. I think there was a letter sent to everyone, and I think that maybe we had wanted to get a presentation from traffic study, which doesn't appear to be here. I'd like to, is Bob, are you here? Okay. Can you step forward, please? It's my understanding there's been a study done about, what is it called, slow-moving vehicles?
That's correct.
Okay. If you could be brief but succinct, please, sir.
Right. Okay. So I'm Bob Murphy, KCI Technologies, and that's correct. We did a study for the Transportation Licensing Commission on slow-moving vehicles, and I'm not going to go into much detail on that. It's a very detailed study with a lot of analysis and a lot of recommendations and suggestions. But just for some background, this study looked in detail at what are called the slow-moving vehicles, and those are the horse carriages, low-speed vehicles, which are the golf cart type vehicles that you see around downtown, the pedal carriages, and the petty cabs. And the purpose of the study was to look in more detail and follow up on a study we did a couple years ago to see if there were more, if there was more direction we could give in terms of reducing the traffic impacts of these slow-moving vehicles, and also making sure that we were trying to enhance safety to the greatest extent possible. As everybody knows, there's been an increase over the years of these slow-moving vehicles, and they have impacted traffic at certain locations. In our previous study, we identified some recommendations to try to mitigate that, but those were really focused primarily on the pedal carriages and to a lesser extent on the horse-drawn carriages and the pedal cabs. We did not look in that study at the low-speed vehicles. So this included a more in-depth study of all the slow-moving vehicles. And I think, I can go into as much detail in questions and answers as you would like. But what I thought I would do is just focus on kind of the issue that's related to today's agenda, and that is the horse-drawn carriages. So one of the conclusions that we reached after observing the current stand on 2nd Avenue was that the stand is not long enough to accommodate all the carriages that are in operation. And I believe that was also confirmed at the last Traffic and Parking Commission by one of the carriage operators. So we concur with that. But I think even more importantly, one of the issues that we felt most concern about related to this operation was that because the stand wasn't long enough, when additional carriages would come to the back of the stand where there was already carriages loaded up in the zone, they would not have anywhere to go. In some cases, they would be slowing traffic down at the intersection of 2nd and Broadway. And just overall, that operation we felt like was problematic from a traffic operational and safety standpoint. So we've made several suggestions. First of all, we recommend that that carriage stand be relocated from 2nd Avenue. And we identified two potential locations. One would be on the north side of Broadway, just west of 1st Avenue. This would be in along the frontage of where the Hard Rock Cafe is. And then the other location would be on the east side of 1st Avenue, south of Broadway. So this would be opposite where Acme is currently located. Each of those locations has more storage capabilities, and we feel like it would have less impact overall on traffic operations. Some of the other recommendations we had with that is one was potentially to explore for the Transportation Licensing Commission actually staffing the carriage stands. So this would be an employee potentially from the Nashville Downtown Partnership who would just help marshal the carriages in their operation so that they were better organized in terms of how they were entering and exiting the stand location, and also there to ensure that the regulations of the transportation licensing, the metro regulations in terms of horse carriage operation were being enforced. Another optional recommendation we had was to limit the number of carriages at a stand at any one location at any one time, and that would particularly come into play if the carriage stand was maintained at 2nd Avenue because the limitation on the ability to stack enough carriages at that location. We also looked at alternate routes, and we did recommend some other potential routes. I think one of the things to recognize is that the routes for the horse carriages are limited because we want to locate them along streets that don't have high traffic volumes or high speeds. The horses can't really negotiate steep grades, and also the carriage operators and the people that utilize the carriages would obviously want to go someplace that has some scenic quality to it as opposed to sticking them out somewhere farther away. So we did have a couple of recommendations in particular routes, a potential route near the stadium on the east side of the river, also one around Bicentennial Mall. And one of the ideas we had about this, too, is that these routes could actually be operated in addition to the current routes, and in particular when the current routes are not possible because of street closures that take place because of downtown events, that these locations could serve as alternates for the carriage operators so that they could utilize those routes in those time periods. So with that, I'll close and just be willing to answer any questions you might have.
Before questions, Ms. Marshall, is this being considered by the licensing board for horse-drawn carriages at the present time as well?
Mr. Billy Fields, with the Director of Transportation and License Commission, is with us today. If you would like to ask him that question.
Mr. Fields, is this under consideration by your group as well?
Actually, the Transportation Licensing Commission looks to the Traffic and Parking Commission on any sort of issue related to horses, the stands and routes and that sort of thing. And that's pretty much what our code requires. Is we certainly are ready for consultation. We'll share information with you, but we think that's your expertise rather than the commission's. Okay.
Fine. Thank you. Any questions of Mr. Yes, Ms. Marshall.
Just a little clarification on.
Mr.
So
Knopf.
this board oversees parking, and if we were to change any kind of on-street parking, it's a new business item for you guys. If we change routes and zones and stuff, it kind of gets into a gray area, and it goes to Mr. Fields' commission. So we don't have to worry about the zones and the routes today. You don't even have enough information to make a decision, and maybe even not the parking. But that's what's on the agenda today, is to discuss the parking. The zones and all, we'll come back to that sometime.
Yes, Ms. Fabry.
I think Feller may be in front of me, but I had a question for Mr. Murphy about the proposed locations on the north and, the east and west side of Broadway. So in front of Acme and Hard Rock, are you thinking either or is there advantages to having a few on each side?
Either or.
Mr. Brown.
You said something about around the Tennessee, down there around Jefferson Street. Is there going to be any activity for horse carriages down in that area? Everybody that wants to ride a carriage is wanting to be around Broad or Church. And if you put them across the river over there around the ball field, that's not going to be a scenic route for horse carriages.
Well, I mean, we felt like there's certainly some scenic attributes to both of those locations. I think in terms of, are those adequate alternatives to the horse carriage companies? I think that remains to be seen. But in terms of trying to find locations that move them away from really the center of downtown where there's so much traffic and congestion, those were the recommendations we came up with, and particularly, like I said, recognizing that you're pretty limited in terms of other streets because of grades.
All right. How many horse carriages will it accommodate if you put them there on Broad, on each side of Broad? How many will it accommodate?
I forget exactly what we came up with. Are you saying on
both sides?
On both sides?
Yes, sir.
I think we're talking about somewhere in the range of about 12 to 15.
How would you determine who can come and who can't come if all of these carriages show up at one time?
Well, I don't have a recommendation to that. I think currently they're limited in terms of how many can operate at one time. Yeah.
Four. Is that what you said? Yeah. At the most. So that would be between the people that's got the horse carriages, who's coming and who's not?
Typically, the operations of the carriage companies are going to allow as many as they have license to be on the street at any one given time during the evening hours. It's been practiced that you're not going to get them all out. There could be a total of 16. I'm not going to say it's never happened, but typically you're not going to have all of them out at the same time.
Okay. All right. Thank you.
Ms. Woods.
I'd like to, thank you. I'd like to make a motion that we defer any action, if we could postpone this for a month, that we need to do. I think some groups are meeting and want to come back with some recommendations.
Okay, we have a motion to defer this item. Is there a second?
Second.
We have a first and a second.
Mr. Chair.
Before we vote.
Yes.
were you
Okay,
saying-
well, we have a
Yeah, I was
motion
gonna
on the
ask-
floor. So we have a motion on
I
the
just was
floor.
going to ask if you want to make sure we're good on all the testimony.
Okay. Are there, I think, yeah, they were here. I know there's other people that wanted to speak who also are not here, and that's why I think what may be a good idea would be to defer all public hearing until we have our meeting. And then if Mr. Murphy could make sure we get a copy of the study so we can read it. But I'll defer to fellow commissioners on that, because I think the horse-drawn people we heard the last time.
Yeah, and I just kind of summarize it, and we're not ready today, but what's on the table right now, and we're working with Mr. Fields, because right now in front of Hard Rock, it's taxi cab stand. And so what we'd like to do is review Bob's study, get with the horse carriage companies, get with the businesses that'll be affected. Diane is going to arrange all this, I'm sure. And we're talking about these two locations to us appear pretty good, but we'd like to get everybody involved to see if it works for them. And if so, maybe there's a queuing area around First Avenue for some of the excess wagons. But for today, I kind of agree with the deferral because there's too many loose ends.
I also just want to chime in on that, is if we can coordinate with MTA too. I know the circuit parks there on the north side in front of Hard Rock too, so making sure we're, all coordinating on that. Thank you.
Thank you. All right, so we have a first and a second. All in favor?
Aye.
Any opposed? Okay. The motion will be deferred till the April 9th meeting. I think that's correct.
Which is important time for carriages.
Okay. All right. So we'll try to get a resolution then. Okay. All right. The next item is, Ms. Curran, you had asked for that item G, the authorized modification of residential permit parking on South 10th Street from 5 p.m. to 7 a.m. with 2 hours for non-permit parking to 24 hours residential permit parking only. This was requested by Councilmember Withers. You'd asked for this to
Yeah.
be removed.
I guess just two questions. The main one is I didn't understand which sections of 10th this is, because there are a number of commercial strips in that area. So that was the main one, and whether or not it is by houses that have, because I know there's a lot of off-street parking for some of the housing, new kind of townhouses there.
This was originally approved by the commission in October for it to be residential permit parking with the hours of 5 p.m. to 7 a.m., and it's from Woodland to Russell Street. And due to concerns with enforcement in that area, the council member and the residents have requested that it be changed to 24-hour residential permit parking.
So is there not off-street parking for that section?
At this particular location, there is not off-street parking.
Okay. So it's not for the townhouses that have the parking
It
lot?
is not. There is a townhouse development there.
Okay.
That's what that is for.
Okay, then that answers my question. So I'll move approval for this one.
Okay, we have a motion to approve. Yes, Ms. Babb.
Well, I just want to clarify, so it's from Russell to Woodland, right? What residence is it serving?
There is a townhouse there.
Oh, the townhouse that has
Yes.
parking behind it that faces 10th?
Yes.
Oh, so it is for the townhouse. I thought you had said it was not.
It is a townhouse, and the residents have limited on-street parking at the site. not enough to accommodate the residents. The commission approved this in October for it to be residential permit parking from 5 p.m. to 7 a.m.
Well, it's interesting because, I mean, there's a lot of commercial too, so it seemed like a good, shared, but, compromise, whereas opposed to now this is just, it's all residential. Okay, well, I know
The
we've got
request
a
that we
motion on the floor, so,
Like I stated, the request that we received to change it was from the residents and the council members when we met with them. Because with you adding the 2-hour in there, an officer has to go out, they have to note a vehicle's license plate number, and then 2 hours later, they'll come back on the next rotation. So it means that a vehicle could sit there longer than the 2-hour limit based on current enforcement. That's why we're recommending the change.
and it'll be on both sides?
It's only on the one side.
Only on the one side?
Only one side, the
So
east
that's
side.
the east side, okay. That's just confusing, so Russell to Woodland, though?
It's a real narrow stretch.
Those are relatively new townhouses, is that right?
It is. When you're going to Russell further south. Kobe, can you pan just a little bit? No, go up, yeah, so that we can, out, yeah, there we go. So there are, just south of Russell, those are new, with that commercial corner at 10th, so heading toward Fatherland.
Right.
So if it was right out in front of them, that would make more sense.
It's right in front of those townhouses.
Oh, it is right in front.
Right in front of the townhouses.
Okay, so not from Russell to Woodland.
No, no.
Would you be okay with that?
So we have a first. Is there a second? We have a first and a second. Is there any further discussion? Okay. All in favor?
Aye.
Any opposed? Okay, the motion passes. All right. Next item, new business item is the authorized residential permit parking from 12 p.m. to 12 a.m. on 45th Avenue North from Nebraska Avenue to Utah Avenue, requested by Council Member Kathleen Murphy. Is Ms. Murphy here? Okay. Staff, can you provide some insight?
What we did at last month's meeting, we had some questions as it related to this because it is a side street on 45th Avenue between Nebraska and Utah. There's 3 homes and 1 vacant lot. And the question that we had staff-wise, did they have available off-street parking? They do at the front of their properties, but not on the side of the properties. And that's why they're requesting this to be residential permit parking. We do have a petition form. We have a letter of support from the council member. But we do have three petitions that are in objection to it. They do not want it done because they're under the opinion that this will take the parking that's currently being utilized there by people other than non-residents and push it over onto their streets. And that's their concerns.
Is there anyone here concerned about this issue? Okay. Is she here? Ms. Murphy? No, she's not here because I asked. Okay.
It's on 45th Avenue from Nebraska to Utah.
Is there any other permit parking in that neighborhood at the
There
present time?
is permit parking on Park Avenue at 51st, but this is the only permit parking at this side.
And you said they have permit parking on the front side of those houses, or?
They have on-street parking in front of their homes, but they want the residential permit parking to be beside of their homes on 45th Avenue.
That seems unusual from what we normally do. Is that not, that is unusual?
It's an odd request, but since we got a letter from the council member and a petition form and we reviewed it,
And did you indicate that, was there a petition signed, and then
There
there's
is a
also been
petition form.
letters in opposition?
There are 3 letters in opposition to it.
Okay,
We do have the petition form, and we do have the letter from the council member.
okay. Well, the council member's not here, and it sounds like, I think it might be important to commissioners to hear from her. Okay. All right, we have a motion to defer. Is there a second, please? All right, we have a first and a second on deferral. Any discussion? Okay. All in favor of deferring this item to the April 9th meeting?
Aye.
All opposed? None. Okay, the item's been deferred, and if the council member could attend, please, that would be great. Okay. All right, next item is to extend the agreement between Metro and 511 Union Avenue, Nashville, for up to 100 parking spaces in the library, the garage, from the current term ending September 30th, 2027 to December 31, 2030, requested by 511 Union Nashville LLC. All right, can staff provide some background, please?
The applicant is with us. Hello, Mr. Fletcher.
All right, Mr. Fletcher, an alumnus of the commission.
Yeah.
All right. Anyone has any thoughts, questions? or concerns?
Sean has a very good explanation. We've talked
Okay,
about it, but if
Sean,
Sean, you want
Mr.
to-
Henry,
Yeah.
please step forward.
Hate to call you out, but you can do it better than I will.
All right. Please state your name for the record.
My name is Sean Henry, 315 Dedrick Street, with the law firm of Tunick and White, represent 511 Partnership. Congratulations, Mr. Chairman. I haven't been here since you've been appointed to that seat. Luckily, you've got the former chairman next to you. So this goes back to a lease agreement that Metro executed with 511, which is the city center building, for essentially it was a 12-year term, 12-year lease term for 100 parking spaces. This request is really to make that a 15-year term, so we're looking for a 3-year extension on that lease agreement. No increase in the number of parking spaces. This is for the library parking garage. And so we first reached out to Tom Turner and asked him about that because the Downtown Partnership has the management control of that public library. And as you may know, it's under expansion right now. So they're adding about 300 parking spaces there. So we're not taking anything away from that expansion of that parking garage, merely a continuation of the same number of parking spaces for an additional 3 years.
And I'll chime in. Mr. Turner and his and the Downtown Partnership supports the agreement.
All right. Thank you, Mr. Henry. Any comments?
Is this where they pay for these spaces, or what is it? I don't know the agreement.
Yes, sir. Councilman, these are market rate spaces that we're paying market share for those.
Okay,
All right.
thanks.
All right. May I have a motion to approve, please?
Move to approve.
We have a first. Is there a second? Second. We have a first and a second. All in favor?
Aye.
Any opposed? None opposed. Thank you, Mr. Henry. Mr. Fletcher, thanks for coming back. Okay. Next item on the agenda is consideration of the rescission of the commission's prior action restricting trucks over 8 tons on 51st Avenue. I'm going to defer to legal counsel for an explanation, please.
Yes, sir. Hang on just a second. So I gave this explanation at the last meeting, but a couple of you were not here. I see we have exactly 7 members present, and that is significant because the reason we have to kind of do a redo on this one is that the motion was to rescind the prior action of the commission, which was to put in place the truck restriction on trucks over 8 tons on 51st Avenue. And at the time, I did not realize that there were only 6 of you there, I guess February being a month when lots of people had flu and whatnot. And the rules of the commission require that when you're rescinding one of your prior actions, you have to do it by a 3/4 majority of the entire sitting board. So the entire board, the entire commission's makeup is 9 members, so that 7 out of 9 is required to rescind your prior action. So you all would have to take a unanimous vote today to meet that standard. And at last month's meeting, the vote was unanimous to rescind. It just wasn't enough people there to meet that 3/4 majority that was required. But the basis of the issue was that the metropolitan government received some correspondence between the Federal Highway Administration and the Tennessee Department of Transportation. And the Tennessee Department of Transportation was answering a question that was posed by the Federal Highway Commission regarding some compliance with some federal regulations of that action that the Traffic and Parking Commission took to implement the truck restriction on 51st Avenue. And the Tennessee Department of Transportation did conclude that there was a violation of some federal regulations that are codified at 23 CFR Code of Federal Regulations 658.19. They looked at multiple subsections of that section. They first looked at subsection D, which was the question that was actually posed to them by the Federal Highway Administration. They actually concluded that that was not violated because that talks about the distance from the truck exit of the highway being 1 road mile, and the distance was not that far, or was farther than that, I think. So D was not applicable. But they looked at A and found that A was violated. And A provides that no state may enact or enforce any law denying reasonable access to vehicles with dimensions authorized by the Surface Transportation Assistance Act between the nationwide network and terminals and facilities for food, fuels, repairs, and rest. And part of their conclusion was also based on another subsection of that same section, 658.19, which was I, 2, little Roman numeral 2, said that all such restrictions must be based on an engineering study and analysis. In the present case, when the action was taken to restrict the truck access on 51st, there was a considerable amount of anecdotal testimony, but the only engineering analysis that had been done was done by RPM Transportation, and that actually concluded that 51st should remain open to truck traffic. So that did not support the ultimate action of the board. So for those reasons, TDOT concluded that 658.19A was violated. And they said the appropriate action at this time is to forward our analysis to Nashville and give them time while the litigation is pending, because this is also a matter that has pending litigation that is currently ongoing relating to it, involving the commission and the business, Marathon Oil, and some of its subsidiaries. So they said to give them time while the litigation is pending to reconsider the commission's action and explore some other possible resolution of the situation. So our recommendation was to basically comply with what TDOT was asking the commission to do. And at the last meeting, there was also discussion of perhaps doing an engineering analysis such as would have potentially supported other action had we had it available when the action was previously taken. That engineering analysis could be done now, and that if it should conclude that measures such as the original restriction or other safety measures were justified based on that engineering analysis, then the commission could come back to the issue and address those recommendations at that time.
Yes, Ms. Babber.
Well, I was just curious, so what is staff recommending? Sounds like we're waiting on a lot of studies and information to come to us, and so before we take any action, I just want to see, what is staff recommending?
Well, I don't want to get into, I'm not going to cross what legal is recommending, so I'm going to follow our legal representation on that. But I want to assure this audience and this panel, regardless of what is decided today on rescinding or not rescinding, we're moving forward with a safety study. You've heard us say that term before, safety study. And so we want to pursue that study regardless of what you guys decide. We owe it to this neighborhood. We owe it to the council person. And so, and that's not a business item. That's just something we're going to do at Public Works anyway.
But seeing something on the agenda, it would be good to know, does staff, could you make a recommendation that we should rescind today or not rescind today?
I do honor the commissioner's letter and Federal Highways letter that they've sent. And I don't know if you've had a chance to read it, but we did pass it around a couple months ago. And based on everything, yes, I recommend rescinding pending the safety study, not just let this thing fall behind the file cabinet. And we will pursue that safety study that we're reviewing the scope today, right, Bob? We've got the scope in hand, and we're all reviewing it to make sure we get what we want out of that study. So I'm recommending rescinding the vote that was put in place 2 months ago or whenever it was. And we did that last month. We just didn't have the 75%. We did vote to rescind last month, and we just didn't have the 75 that's chartered in charter.
Mr. Hager.
When's the study going to be finished, though?
Well, we haven't officially gotten a PO in place, but KCI Technologies are going to, I guess, if you get the PO in place, you're probably already working on it behind the scenes, but we've got a scope in place that KCI is going to follow. We met with the council person and some of the neighbors. We want you to have what you want in that study. We want Ms. Roberts to have what she wants in that study, and the neighbors to have what they want in the study. So right now, we're all reviewing this proposal from KCI. But I would say, Bob, do you remember what was in that proposal? Was it a 2-month?
I think that's what we were talking about.
About 2 months.
So has it started yet? No. So if we, let me ask legal, if we defer this again, does that jeopardize our federal funding?
I mean, I can't answer that in a definitive way. I will tell you that there have been some delays already. So the original letter from TDOT was actually dated December 20th. And because of the holidays, we really didn't get that in time to put it on the January agenda because there were a lot of non-business days in between that date when it was sent and when it was actually received and when the agenda closed. So that was already a delay. So we got it on the February agenda and, thought we'd taken action, but then realized that we hadn't followed our own rule. And so that's kind of caused yet another delay. And, as I mentioned to the board last month, there is a pending lawsuit. There is a stay that was issued by the court in that case. So as a result of that, the truck restriction has never actually to date been implemented. The trucks are continuing to use 51st presently. However, we are certainly concerned about it. I mean, so far, TDOT seems to be being patient with us, but I don't know to what degree that is based on their understanding, because I've been keeping them advised of what's been going on, that we're making every good faith effort to follow their recommendation. If at some point they perceive that we're not doing that, then I do think that there is some risk. We don't have any examples in the Federal Highway Administration context of situations that we know of where federal funding was refused or withdrawn to Metro on the basis of a federal highway requirement violation in the past. But I have seen an example of that was done in another city, And we've had examples of it with other federal agencies and other metro departments where that kind of thing has happened. So, I think it would be up to, both the federal and the state departments. But it's certainly of concern. And then there's also concern about the pending litigation and, whether if TDOT deems the delay is too great, they would feel a need to take some kind of action of their own. Because under the federal regulations, it is actually the state that has the authority to ensure that the local governments comply with those regulations. So at some point, if they don't feel like we're acting on that, they might decide to take some legal action of their own.
So it's pending in state court now, is that correct?
That is correct.
And that's in Chancery Court?
Yes, that's correct.
And they put a restraining order where we can't have a weight restriction right now, correct?
Yes.
All right. So if we deferred this, that stay would just stay in effect, would it not?
We were talking about potentially taking y'all into executive session about that case today because we felt that given the amount of public interest in this case that maybe we shouldn't do that. But really to answer more detailed questions about the case like that, I would have to suggest that you talk to the litigators who are actually handling that action and get their impressions in an executive session context. The attorneys are Kate Pham and Laura Fox.
Okay. And so if we move to rescind it today, okay, what does that do? Drop the lawsuit or what?
Yes, I believe, I mean, some of the representatives of the lawsuit are here, but I believe that there was a sort of a tentative settlement concept reached that would go forward if you all reiterate what was done in February, and that would not go forward if you do not.
All right, and then they get through with the study in 2 months. Can you bring this back again if that study complies with federal law or not?
I think you could. We did talk about the fact that there is a provision also in your rules that say, in general, you don't look again at your actions within a 6-month period, but I think that could be suspended. It only takes a 2/3 majority of this group to suspend your own rules, as opposed to a 3/4 majority to rescind your prior actions. And also, I think there was some flexibility in it anyway. So I wouldn't worry about that too much. I think you could look at it again.
Any other comments from commissioners? Yes, Ms. Lee, Ms. Woods.
I'd like some clarification when we get ready to take it, if we rescind and then we come back to take other steps with this, about what our role is. If we're concentrating on pedestrian safety in a residential neighborhood, that's real clear. But if it's not, I guess, we're getting a lot of rules that I feel like are almost outside of our purview. So if we could get a lot of clarification on that with the next step and with the weight of the trucks, things that we can govern, that would be very helpful.
So I think if I hear you correctly, what we're looking for is a little clarification on the exact role of the commission in restricting truck traffic as it relates to safety.
Right. You have the authority, when it comes to trucks, you have the authority to do what they call weight restrictions, and that's because the bridge won't support a truck, and so you restrict that road because of weight. In this case, it's more of a, and I'm going to use this term very loosely, it's more of a nuisance restriction. The weight of the truck is not tearing up the roads. We're not restricting it because of the weight. The road can't handle the weight of the truck. It's because of safety or inconvenience or cut-through traffic. A lot of times when you implement a truck restriction and it's not based on weight, even though we put a weight tab on it, it's based on cut-through/nuisance. It's almost like a traffic calming program, but it gets the trucks instead. And you have the authority to prohibit trucks on any road based on weight or based on route. And that's what we're talking about today, route and safety.
Because there
Pedestrian
are,
safety.
yeah.
And that's what this study's going to cover. It's not just going to look at pedestrian safety and the new layout of the roadway. It's going to look at the safety of the drivers of those trucks, too, and the route they would be taking from there out if we restrict it.
But what about pedestrian
And
safety?
pedestrians, for sure. That's the big objective of the study, yes.
I would just add to that a little bit. I think the question is maybe twofold. That certainly you do have authority both under the charter and the Metro Code to implement truck restrictions. But the question is, to what extent do these federal regulations curtail that authority? And I think as long as we are in compliance with those federal regulations, as long as we're not curtailing that reasonable access without having a safety and engineering analysis to support it, then we would be in better shape. One thing that we can certainly do, and that I have already offered to do, I'm sure with everyone's consent, would be to share the results of the safety and engineering analysis with the Tennessee Department of Transportation.
We're going to volley it back and forth. One more thing. A weight restriction, just because we're talking about the subject now, a weight restriction prohibits any truck over that weight to go in that area, whatever area that is. A truck restriction that we're talking about still allows deliveries and buses and school buses and that kind of thing. It prevents going from point A to point B if you can get to point B a different way. But if you're serving something within that zone, you still can get to your destination. UPS, the gas tankers that serve any gas stations along that route, that kind of thing.
This is for legal. From your standpoint, legal, what should we do?
So I have talked this over with a number of attorneys in my office, and I believe that we have consensus that our recommendation is to rescind and to pursue the safety and engineering analysis, and then wait and see what that says, share it with TDOT, and then proceed from there.
Okay, thank you.
Can I have one more?
Yes, Mr. Hager, please.
And if we rescind it, and after we get the study in, we can bring it back, or do we have to wait a certain time period?
So hang on just a second. Let me flip to that rule so that we can talk about that. So the rules of the commission say, once an appeal has been acted on by the commission, there shall be a waiting period of 6 months before a citizen or council member is allowed to present the same appeal at the same location. This does not rule out the possibility of the commission choosing to reconsider a vote under the normal parliamentary procedures. So given that wording of that rule, while we normally wouldn't revisit something within the 6-month period, I think you actually do have the ability to do it.
So we can bring it back within 6 months then?
Yes.
Okay.
Okay. Is there any motion on this item or further discussion?
I have one last question. So it says, I'm looking through the letter now, and it says, while the litigation is pending, they recommend we reconsider and explore other options. Is there only, does reconsider mean we have to rescind our own action, or is there an interim route where we postpone our own, is there some way to postpone our action while we reconsider, or does reconsider only mean rescind?
I really appreciate you asking that question, actually, because that's something I did want to clear up a little bit from the last meeting. I was quoting the TDOT letter and using their word reconsider. From like a Robert's Rules of Parliamentary Procedure perspective, however, a motion to reconsider can actually only be taken like within a 24-hour period of the original motion. And so if you want to redo what you did before, revisit it or change it or void it, then you actually need a motion to amend or a motion to rescind, which may be taken at any point subsequently. So we're recommending a motion to rescind.
Okay, so it sounds like we need a parliamentarian future meetings. Okay. And the only thing I would ask is to make sure that we have a full copy of minutes so we can approve these at our next meeting. So if you would make that a priority in your review, please. Okay. do we have a motion by anyone? Yes, Chip.
Did you want to take your motions before opening the public hearing, or?
Yeah.
I don't
Well-
know if you want a public hearing, but there's an announcement in attendance.
And I would ask, we did hear from one side of the litigation last month, but we did not hear from the neighborhood association. Would it be appropriate to have a public hearing, or, that's a question.
Because last meeting, Ms. Roberts spoke and Mr. Lee representing thing. I know some people brought their children here, and I'm a big advocate of making sure, particularly those who bring children, so that children can learn the process for future good citizenship, and that's something we teach all our Boy Scouts as a Boy Scout leader. So are there, I know I walked in, someone with a stroller, and I see someone sitting in the front with a couple of children who've been behaving quite nicely. So thank you for bringing that up. I think it would be, since we've heard from Ms. Roberts and Mr. Lee, I think it'd be helpful to hear from some citizens who, whether for or con. So who would like to speak first? And just please make sure you identify yourself when you step forward, please.
Sure. Hi. Matthew Siegel, 4606 Illinois Avenue. And I think I might take 4 minutes, but I think I can keep about 10 people from speaking if I do that, so with your permission. Thank you, obviously, for your service to Nashville and your time and attention to the matter. This is really important stuff to our neighborhood. We appreciate your concern, and the time you volunteer. Now the fourth time we've been here in front of the Traffic and Parking Commission. We would have been here last month. You've gone over that we really didn't have any opportunity to do that. We were unaware of the existence of any of this correspondence between TDOT, FHA, Metro. And it sounds like that letter was a bit of a surprise even to some of the members of the commission. So this is thank you, Ms. Kern, for giving us this time to speak, because I think that this is the hearing we kind of wanted last time. We definitely don't need to rehash every detail. I won't do that. I kind of have 3 brief points. One, this has been and will always be about safety. We've counted 19 new businesses, bars, restaurants, exercise studio, boutiques, breweries along 51st Avenue in the past 2 years or so. All of them are retail. Many of them are pedestrian dependent. A majority of them, and every single one we spoke with, signed the petition in favor of the restriction that was submitted to you in August 2017. Since the last meeting alone, 300 neighbors, more than 300 neighbors, have signed a petition, again, supporting leaving the restriction in place. Beyond that, 51st Avenue is now a complete street. That means just 2 regular travel lanes, a turn lane, a 2-way bike lane, street parking, and over a mile of new sidewalks. The RPM traffic study from May 2017 was completed under the previous conditions, with some awareness of the upcoming changes. We also have 9 painted pedestrian crosswalks, a dog park, a school zone encompassing 2 of those crosswalks. Lastly, as you recall, a tanker truck exploded only a few years ago on Centennial Boulevard. The investigation into that indicated the driver was recklessly going at a high rate of speed, well above posted limits. Thankfully, as a road with 4 travel lanes and no sidewalks in that stretch, no one was harmed, although the fuel entered our drain and sewer system and caused exploding manhole covers throughout the nations. It's a good video if you want to check it out. Next time, if that same blast were to occur with the same radius on 51st, we would not be so lucky. We as a neighborhood have been crying out for attention on this point. It is just that unsafe. We firmly believe that unfettered access for trucks using Centennial to Briley Parkway represents reasonable access to the national network as defined by these federal regulations. The Briley interchange is a similar distance to the on-ramp at I-40 from the fuel terminals. The flyover ramp that connects Briley to I-40 cost taxpayers $32 million. It was the second largest Recovery Act project in the entire state. It was lauded by the governor, the TDOT commissioner at the time, for reducing congestion in West Nashville and taking freight off our roads. Lastly, I'd like to talk about what the letter that was forwarded to Metro Legal did and did not say, and you've already gone over a little bit of this. It did not say that funding was at risk. It did not cite any cases, any court decisions, any other examples in Nashville or Tennessee as justification for invoking this provision, A. It didn't even ask them to look at A. They asked them to look at D, and they said, wait, we'll look at some other stuff too, because I would contend they were seeking this conclusion. In fact, the FHA asked TDOT only to investigate the 1-mile provision. The truck restriction passed that test. Here's what the letter did say, however. We believe the appropriate action at this time is to forward our analysis to Nashville and give them time, while the litigation is pending, to reconsider the Commission's action and explore some other possible resolution to the situation. It also said that the current restriction could be justified on the basis of a safety study. So that's what we're asking for today. Do not rescind the restriction. Instead, give the safety study that has already been commissioned the time to run its course. As noted by TDOT, the truck restriction is currently stayed. The matter is pending in Chancery Court. And as Public Works will tell you, and already did, this is a sophisticated study, and we'd all like to see the results before considering our next moves. In the meantime, we'd also like you to look further into the issue of reasonable access under the regulations and conclude for yourself whether Briley Parkway via Centennial meets that standard. I'd also like to point out that a rival fuel terminal company, which is not part of the legal action against Metro, it should be noted, already utilizes that interchange for access, so it might be worth studying further. Thank you.
Thank you, sir. Please keep your, identify yourself and keep your comments brief, please.
Michael Kenner. I am a real estate developer. I also put on an event that caused the 51st Avenue corridor to be changed from 4 lanes down to 2 lanes. I own a building at 5010 Illinois. I am a father of a 7-year-old child who enjoys riding her bike up and down that street. The other day, I was standing on the top of my building because we have rooftop decks, looking down on the 51st Avenue. It was on a Friday where the weather was amazing. There were probably over 400 people congregating at the dog park across the street from my building. My building is the Phoenix on 51st, where a new butcher shop went. If you look to the left, you'll go down and you'll see 51st Taproom North. Altogether, there's probably about 450 people in a 2-block radius. Now, my question to Metro Legal is, if you guys rescind this and then a tanker flips over and blows up, I can tell you the blast radius of those tanker trucks because I went and personally measured one when it flipped over on Centennial. And that tanker truck would kill everyone in my building, everyone in my butcher shop, and everyone hanging out in front of the dog park. So if you guys rescind this motion and choose to not take action today and choose to put off your vote, would that open you up for liability for the families of those people who would die in such tanker action because of your inability to take action? My second question to you guys would be, if you really look at the RPM traffic study that was originally done, it was based on a very flawed perception of how trucks travel. It's based on a linear distance. So if you click a mouse from the exit at 46th Avenue and then put it to the Marathon Terminal, that's how RPM did that traffic study. Now, last time I checked, trucks can't grow wings and fly. They have to turn on streets and stop at stop signs. So the whole entire basis of the economic viability of the access was based on a linear distance. Now, if you take a linear distance from Briley, yes, it is longer, but the actual travel distance is a 1-minute difference for trucks leaving the 46 exit, and it's less than trucks coming off Briley Parkway. And that's the flaw of that study that was initially done. So as a business owner, as a father, as a member who lives in this neighborhood, and as someone who owns a very large, very expensive structure on 51st, and someone who's ex-military and has dealt with improvised explosive devices and weapons of mass destruction, I can tell you one thing. If I was ever going to put a single piece of weapon of mass destruction in the middle of a neighborhood or drop an IED in the middle of a neighborhood to cause mass casualties, it would be a tanker truck. And if you look at how one flips over and explodes and look at those videos from what happened on Centennial, you will see the destruction that can happen on 51st Avenue.
Thank you very much. Did you want, please step forward and identify yourself, please.
My name is Kelly Babcock. I live at 4608 Indiana Avenue across the street from Cockrell Elementary School. I'll be brief because these guys covered it a lot better. I just want to speak to the safety of the school children. The tanker trucks are going down Indiana Avenue. They're using 51st, but they're using Indiana Avenue as a cut through as well, which is in a school zone. We have photos of tanker trucks in school zones, and that's one of my primary concerns. I see it on a daily basis, tanker trucks coming down Indiana Avenue in front of the elementary school where children play in the schoolyard, and so that's my main concern. Thank you.
Thank you very much. Is there anyone else, please?
Hi, my name is Timothy Brown. I live at 5303A, Kentucky. And just to add on to what Ms. Babcock just said, those side roads, Indiana, Illinois, Michigan, they already have weight restrictions posted at the intersections of 51st. So any tanker truck that was to go down 47th was already breaking an existing weight restriction besides going through the school zones. So thanks.
Thank you very much, sir.
I'll be brief as well.
Sure.
I'm Janelle Lacey. I live on Indiana Avenue. I've been there for 11 years, and I have a almost 7-year-old son and a 20-month-old son. And we walk and run and play in the neighborhood. We love to walk to the park near our friend Kelly. And even my 7-year-old makes the observation that trucks do not stop for us on 51st Avenue and how unsafe it is. And really from walking it pretty much every day with my family, and I'm an avid runner as well, I can tell you that not only are they not stopping, I question whether they even can because of the speed that they go down that street and the distance, the sight distance. So we're really looking forward to the safety study. Would ask for you to defer any action until we get it. Thank you.
Thank you.
My name is Meredith Wallner. I live at 5511 California. I don't really have a lot to say except for I have 3 children. I homeschool them, so we're home a lot, and we like to ride our bikes around the neighborhood and walk around the neighborhood, and the Nations is a great place to do that except for the trucks that zoom down, and we can't even use the bike lanes because I'm scared of like the little poles that are protecting the bike lanes. That's not going to do much against the truck. So that's really all I have to say.
Thank you for speaking. Is there anyone? Okay. All right.
Well, in light of the testimony, I just want to confirm with staff, your recommendation then today for this commission?
I'm sticking with the recommendation from last month. I recommend rescinding the action, and I agree with the councilman that we're not going to wait 6 months to hear this again. As soon as that study's done, it'll be right in front of this panel. But I recommended it last month. I'm going to stick with that. I recommend rescinding the action.
So if we did make a motion for that, could we go ahead and tag on, it's legal, that they could come back within less than 6 months once that safety study is available?
So the way I read the rule, you can do a couple of things. You can do it any way you want to, really. But the rule provides that it's only a citizen or a council member who can't bring it back within the 6-month period. So if the commissioners were to bring it back sua sponte, then you could bring it back anytime you wanted to upon receipt of the study or whatever. So that's one option. If you wanted them to have the ability to bring it back, then you could just suspend that rule, which again requires a 2/3 majority vote to do that. But that would also be an option.
Okay, and I have another follow-up question. So on the study, we're thinking 2 months, so that'll be conducted while school is going on, so those numbers will be captured as part of the study? Okay, and we're thinking then by May meeting, it would potentially be available, or could you commit to a schedule? Is that unfair?
Well, I keep volleying things back at people. I'm waiting on some comments from a few people in this room right now. So KCI cannot start their study until they know what to study, and there's a few people in this room that are going to get them that answer. So take Bob off the hot seat for a minute. He can't agree to a timeline until he gets the go-ahead to start. And that'll be any second now. I just want to get with the council lady one more time on the study itself and the scope.
When does he get to go ahead?
As soon as I get the comments back from the neighborhood on what they want in the study. I received a few today. In-house, we've got our comments. If you're looking for something or you're looking for something, and I know they're looking for something in the study, because we don't want to be going back through this, that the study left something out. So we want this study, whatever it consists of, to be complete.
I mean, we are motivated in some ways to defer because then it would push this issue so that things will happen faster as opposed to it just lingering on.
Well, and my question was, could we acknowledge that we are reconsidering by deferring 2 months and saying we are reconsidering and waiting the study? It hasn't actually taken in effect yet, so nothing's happened. And having it on the agenda in some ways shows we're reconsidering it because we intend to discuss it again.
I mean, I guess it depends how you use the word reconsider. I mean, from a parliamentary perspective, that wouldn't really be anything more than a motion to defer. But, I mean, I can try to characterize it that way to TDOT's general counsel.
Yes, Ms. Woods.
So the action that we took, nothing really changed, right? I mean, nothing really, it's my understanding no right or wrong, nothing's changed. So why are we trying to rescind something that didn't work to begin with? It seemed, I mean, can we just punt till we get all the information back?
So we do have an opinion from the State Department of Transportation that is saying that an action taken by this commission is in violation of federal law.
Right.
So
the state is telling
our
us
recommendation, yes, the state is telling us that in their opinion, this commission has violated federal law. So we're saying our recommendation is to fix that, to rescind your prior action. And part of the reason why it was in violation of federal law is because the action was taken without an engineering analysis and study to support it. So if we can take the action after we get the engineering analysis and study, then it's going to be much more likely to be in compliance with that federal law. So that is why we are recommending that you go ahead and rescind, because, you know, as your legal counsel, I cannot advise you to allow a violation of the law to stand.
Okay. I make a motion that we rescind because from legal, Chip, we violated the law. And I make a motion we rescind, and after the study is done, bring it back.
We have a motion to rescind that has been made with the condition that the issue be brought back. Is that correct, Mr. Brown?
Yes.
Pending the safety study. And I think from what I'm hearing from all the commissioners, it's very important when we approve minutes that discussion of this safety study is included in the minutes, please. Okay? All right, so that is the motion. Is there a second to this motion? There's no second to that motion. Is there a different motion?
Hey, legal, could you tell us what happens if, from a, and I don't know this area very well, so I'm going to butcher this, but from a litigation and chancery court and all that, what happens from the hold or the stay if we don't rescind?
So I did talk to the litigators that were handling that case. Obviously, we want to be very careful in this public meeting context, you know, not to go into too much detail into the inner thoughts of our legal counsel who are handling that lawsuit. But I think I can say very generally that, A, they think that the Chancery Court would issue an injunction, I can't say for sure, that the Chancery Court could issue the injunction if you all don't rescind your action, so that would kind of have the same effect as y'all rescinding your action regardless, except that it might be permanent and wouldn't give you the opportunity to come back and fix it after the study comes in. And and that it would just sort of, it would kind of ruin the tentative settlement that the parties have reached on the assumption that the rescission that happened in February was going to be ratified. And it would also just kind of generally have negative consequences for that litigation.
So are you saying that if we didn't act and they filed an injunction, it could make it permanent?
So they have requested an injunction in that lawsuit. I think the attorneys are here, so they could probably speak to that more intelligently than I can. But they have sought that as part of their relief in that case. So a potential consequence is that the court could grant that, which means, you know, we may be permanently enjoined by a court order. We could appeal that court order, but you know, I would suggest that you go into executive session with Ms. Baum and Ms. Fox to discuss those consequences in more detail if you want to go down that path.
Okay.
I mean, to me, that seems like a kind of a key piece. So, I mean, what would be the process of going to an executive session, or?
I mean, so an executive session is a non-public meeting where basically the attorneys would do an informational session for the commission members, kind of explaining issues in the lawsuit that they would prefer not to discuss in public because of the attorney-client privilege. The commission members cannot deliberate or vote in that context. You can receive information, you can ask questions, they can present information to you, and that's it.
Commissioners, my sense, legal counsel, is that, and I'm not trying to speak for anyone else, but it does appear that, we had minutes of the last meeting that we couldn't get approved because they're still being reviewed. And I think those minutes had some important facts. We have some concern about, we want to keep our options open for the future. We don't want the law to decide that the commission is defunct in this matter. But I think at the same time, without talking to the lawyers involved in the litigation to get their input, which requires executive session, I'm not sure that everyone feels comfortable with the information they've been presented. So I'm just trying to maybe summarize what I think I'm hearing, and we'll let others step forward, and that's the concern, I think.
Do we have pardon my ignorance, do we have lawyers from both sides sitting in with us on this executive session?
No, it would only be Metro's lawyers that would sit with you. You can choose to hear from the lawyers for Marathon Oil. They are present if you wish to.
No, so can we ask to hear from the other lawyers? Or is that going back to the minutes? I missed last
So the question is to be able to hear from the litigators. How do we proceed to that point? Ms.
I mean, we could set up an executive session for you if that is the will of the commission, as soon as everyone is available. I mean, that doesn't have to be public, so it doesn't have to be like publicly noticed and publicly heard. We considered doing that today, but we felt that it would not be ideal just because of the degree of public interest in this issue. And so, rather than go into the degree of detail that they could take you into, I was sort of just prepared to say that in general, it is the consensus of attorneys within my office that we do recommend rescission, that we do think we would have a concern about the Chancery Court lawsuit, there being a potential injunction in that case if the rescission does not occur today. And we do think that it would, derail the potential agreed resolution of that action, and that it would, just generally have a negative impact on our chances of prevailing in that lawsuit.
So question, if we were to hear from the litigators in executive session, whenever that might be, does that provide the commission more time to consider? Because what I'm hearing is I think people feel like maybe we don't have all the facts or all the information. Maybe facts is the wrong term, but all the information pertinent to the matter.
The only problem is that you cannot deliberate or vote in the context of an executive session. So you couldn't take action at that executive session meeting. So we'd either have to schedule another special open meeting of the commission if you don't take action today, or wait until the next following regularly scheduled meeting of the commission.
Or, Chairman, could we take additional testimony today, even though I believe we closed the public hearing? Can we reopen it?
I'll defer to, but I think some of the people we need to hear from are not here. It's Metro legal staff, is that correct?
I don't see Ms. Baum or Ms. Fox here. So, if Ms. Favre's question is, can you all ask questions of people in the audience? I think from a parliamentary perspective, yes, you can.
But we couldn't talk to the legal counsel publicly about the case. Is that correct?
So you can. One suggestion and one thing I've seen done before is that if you have legal counsel present at, like if you have an executive session, say for example, immediately preceding a public meeting, then you could have the legal counsel stay through the public meeting, and you could kind of get the informational presentation in the executive session, and then maybe have some more general statements that the lawyers are comfortable sharing publicly, kind of ratified or verified at the public portion of the meeting.
Yes, Mr. Hager.
But the stay's in effect, so as far as the trucks going up and down 51st, they're still allowed to do that, correct?
Yes.
Okay. So why does it hurt anybody if we passed it one session to get and talk to legal?
I mean, again, that is an action of the court and not an action of this commission correcting the action that TDOT has opined was a violation of those federal regulations. So we would still recommend that you rescind on that basis.
Okay.
Do we have a second?
We do not have a second on the motion.
Go.
Go ahead.
If we can ask questions, I'd certainly like to do that.
Okay. Who would you?
I'd like to ask Mr. Lee or someone from his staff.
All right. Could we have Mr. Lee step forward? Mr. Lee, will you step forward and identify yourself so then we can ask you questions, please? And whoever came with you, please. Okay.
Thank you, Mr. Chairman.
Please identify yourself, and then we'll have Ms. Woods ask you questions.
Certainly. My name's Tom Lee. I'm a partner in the law firm of Frost Brown Todd. This is Alex Fisher, also with our firm, and we represent Marathon Petroleum Company. Happy to answer any questions you have.
So, bottom line, how far away are these two sides from each other? Is there any kind of compromise, or is there... The last time that we voted on this, we thought that there was going to be a different route for the trucks. We first thought Marathon was on board with this, and then we heard that was a surprise to Marathon. And if I'm summarizing this right.
That's correct.
So what needs to happen coming from your end now?
We've said two things publicly about this, and I'm happy to put it in the context of this discussion for you. The first thing we said was in writing. In the litigation that Ms. Costonis has referenced, the court, about a month ago, that's not right, about 6 weeks ago, ordered us to make a status report to the court in writing by February 16, which we did. In that status report, that was the week after this commission met, and we said to the court that because of the commission's vote on February 12, rescinding this action from August, that it was our anticipation that upon the approval of the minutes, which is the way in which you speak, then we would anticipate dismissing the lawsuit without prejudice. So that's because there would be no further need for the lawsuit at that point. That's one. Two, with respect to the issues in the neighborhood, we don't take exception with our neighbors that there are safety issues in the neighborhood. We agree. We have a different idea about them, but we agree. We agree that the remarkable development in the neighborhood that has occurred over the last few years has placed new pressure on intersections, new pressure on whether the lack of signalization or stop signs is appropriate on 51st Avenue, how and whether to handle the increased pedestrian traffic at the neck of 51st Avenue and Centennial Boulevard. what to do about the businesses that have located in the area, some with, frankly, adequate parking and some with not. And so we would like to be a part and have said and repeat to you our sincere desire to be a part of a conversation on those issues. We would also submit to you that this is the worst possible place to have that conversation. We would like to have that conversation where you have conversations, coffee shops, meeting rooms, and would submit to you that this process, unfortunately, has done very little, I would submit, to bring all the parties together. In fact, I think you can tell from the division here, or from the voices here today, it's only divided it. The role of metropolitan government should be, yes, to set appropriate regulations, but in part should be to ensure that neighborhoods are working together. This process has virtually ensured that's impossible, and that shouldn't be the way it should work. Having said that, I would say just one other thing about this that I think is important, and it's of a concern as a Nashvilleian. It's a concern to me. One of the things that we haven't discussed is the October 23rd, 2017 letter from the Federal Highway Administration to TDOT, in which, this is really how this process began, the Federal Highway Administration requested, and this I'll just read this sentence, we request that the Tennessee Department of Transportation evaluate whether the City of Nashville has violated the provisions of, citing the regulation we've discussed earlier, with respect to the restriction of truck traffic on 51st Avenue North. Please be aware that if a violation is determined to have occurred, federal aid highway funding to the City of Nashville could be jeopardized if the restrictions to truck traffic in non-compliance of the regulation are not removed. So,
could I see a copy? Do you mind circulating that? I think that's something.
It was present at the last meeting, but yes, I can get a copy.
Certainly.
Yes.
So that's what TDOT was responding to, and TDOT wrote what you've all seen. So, just to be direct about your question, Commissioner, we very much want to have that conversation. We have, frankly, we've represented to the court that this conversation has reached a point. We think we've got to. We have an obligation, if that representation was not accurate, to frankly let the court know. I think the obligation is still on us to make sure that status report is accurate. We're happy to do that, and wouldn't mind it. But I think we're under some obligation. Ms. Costonis is right. All of us are under an obligation to make sure the court knows how things are proceeding. Thank you.
Okay. Are there any more questions of Mr. Lee, please?
I may, I don't know whether this is the proper question to ask of you or not, but would you agree that the previous study was not inclusive of the current situation of the pedestrian activity, of the increase in commercial development along 51st Avenue, of the increase of pedestrian activity?
Respectfully, Commissioner, I would not agree. I think the testimony before you at both your June and August meetings was, certainly at the August meeting, was that your consultant was certainly aware of the Complete Street project that was underway, and everyone was aware of that in June as well. But I believe your expert stated at the August meeting that there was nothing about the change in the road diet, if you will, on 51st Avenue that changed their recommendations, and that is because Metro's street plan has not been changed. Metro's street plan still provides that 51st Avenue is an arterial roadway. And as an arterial roadway, it is designed for and appropriate for a wide range of uses, including commercial. And I think your expert also testified at your hearings this summer that when the Complete Street project was put into place on 51st Avenue, that the roadbed was constructed in such a way as to continue to manage commercial traffic. It's important, and it was alluded to earlier, I believe, by staff, to note here that even if this regulation is in place in some way, somehow, and enforced, you're going to have truck traffic on 51st Avenue North. In fact, you're going to have gasoline tankers on 51st Avenue North because there is a filling station on 51st Avenue North, and the restriction provides that trucks can go to and from there. But you're also going to have dump trucks. You're also going to have FedEx trucks and UPS trucks that weigh more than 8 tons, as many do. You're going to have construction equipment. You're going to continue to have considerable truck traffic. And I guess the last thing I would say is the other reason I would disagree, Ms. Williams, with respect to the findings is there is not a record of a tanker accident on 51st Avenue. There is a record of a tanker accident on Centennial Boulevard. The previous testimony is correct. The driver was going too fast. The accident report shows that he lost his focus when he was driving, when he got to a curve in the road. That's the advantage of the 51st Avenue route. It's direct. And that was taken into account in the study.
All right, if we could, I'm going to make a point here. If we let each speaker speak, just like everyone else was allowed to speak, and we're not taking comments from the audience, please, during the meeting. That's respectful of everyone's ability to speak, please. So if you could not follow that rule, I'd ask that you leave. Thank you. Please proceed.
Thank you. I hope I've answered your question. Thank you.
So what can we do to get the information that we need to make the right decision?
So while Mr. Lee was speaking, I was also texting with my office, and Ms. Pham could potentially head down here depending on how late you all want to stay. She just wants me to let her know if she wants to, if we want her to head over.
So to summarize, we needed a 3/4%. Even if the rescind motion had been put in place, you needed 75%. And I'm not going to make an assumption on how that was going to turn out, but it sure looked like we might not get 75%.
Well, I'll be glad to second the motion if we need to go, if we want to go back to that, if we need to vote.
I'm not sure what your advice is on that, but you could knock that, you could go ahead and get that off the table if you wanted to make the second and vote on it.
Because there was a motion that was presented, and it was waiting for a second, and a second had not occurred. So is...
Need a new motion?
Commissioner Brown, you
Mr. Brown, you can
make your motion again,
please.
I make this motion on the fact from what Metro Legal says, what Chip says, and what the law says. And we can sit here and debate this and kick it back and forth up and down the street, but when it gets in court, from what I see, we're going to lose anyway. And I understand where you folks are coming from. I've had a rock quarry move in my neighborhood. But I make a motion to rescind. And based on what we did, what was it, last meeting? Yes, ma'am?
I would like to just ask one question. If it's rescinded, does that mean all the lawsuits, including the one against me, are dropped?
I'll let Mr. Lee.
I'm happy to answer that, and that's what we said in our filing with the court. We anticipate we would dismiss the lawsuit because the matter would be moot.
So that's
Without prejudice.
That's a yes, without prejudice.
Okay. So, Mr. Brown, would you continue, please?
Yeah, I'd like to make a motion to rescind on what we voted for at the last meeting of February, what was it? 12.
And I will second with the request that in the future we can set up an executive session to ask a lot of to talk a lot with our lawyers before we come here. So I'll second that.
Okay. So we have a motion and a second. Okay. That is a rescission, correct?
Yes.
Okay. So we have a first and a second Is there any further discussion of the motion? If not, I'd like to.
I just have one last question. Would it be possible for us to go ahead and request that this be added back to the agenda upon the completion of the safety study?
Yes.
So we remove it and then we just come back to it as soon as we have all the information from the lawyers and from the safety study that we feel we need?
That could be part of the motion.
Okay. Well, then
Would you like to modify the motion?
I would modify the motion to say we rescind our order per the, requirements of the lawyers and the federal government, but upon the completion of the safety study, we then return this to the agenda for consideration.
All right, so that motion's been modified. So is there a second to that? Am I following correct parliamentary procedure?
I think Mr. Brown and Ms. Woods would have to accept that amendment to the.
Accepted.
Will you accept that, Mr. Brown?
Yes, sir.
All right, I want to be a correct parliamentarian. Okay. We have a first and a second on the motion. We're going to ask for a hand vote on this. All in favor of the motion as presented, please raise your right hand. We have 7 votes, which is what we're required. Is that correct, Ms. Costas? Okay. So, again, I would think it's very important for the minutes to reflect the overriding concern of this commission about safety and the safety study and its priority, please, and that any minutes be prepared in advance so they can be reviewed by the commission so they may be approved at the next meeting. Okay? All right.
As we wrap that up, Mr. Lee, this study is going to include you guys too. It's going to include the neighborhood, it's going to include you guys, it's going to include anybody that wants to participate, so.
Thank you. Thank you, Mr. Knopf.
I think the only other item on here is that we have to meet on April the 9th at a different place. Is that correct?
April 9th meeting will be held at the Metropolitan Health Department, and I think it is 28th Avenue North, but we will send you that information prior to the next meeting.
All right. Is there a motion to adjourn the meeting? Okay. Second. This meeting is now adjourned. Thank you, commissioners.
Thank you.
This has been a service of the Metro Nashville Network. If you would like to see this presentation again, or for more information about this and other programs, visit nashville.gov.